Good afternoon, gentlemen. It is Groundhog Day 2022, and we are recording this first session of marriage practice and procedure because we probably will not be able to meet tomorrow when we had hoped to for our first class on February 3rd because we have this terrific ice storm headed our way, so we'll have to delay a week meeting in person, but this video at least should prevent us from falling behind. What we'll do today is a bit of an introduction, and then we'll talk a little bit about judicial power in the church. We'll say something about church tribunals, tribunal personnel, competence, what the stages of a nullity case are, and the difference between a judicial process and an administrative procedure. I apologize if some of this is repetitious of what you've learned in J-term. Different people have had J-term at different times, so different things may be covered, so I apologize for that. Where we're going to start, actually, is with a famous quotation from a famous book. This is the opening line of a famous book. And it's I won't tell you quite yet what the book is, but the line is, "Happy families are all alike. Every unhappy family is unhappy in its own way." And then the first paragraph following describes what that means in the context of this story. Everything was in confusion in the Oblonskys' house. The wife had discovered that the husband was carrying on an intrigue with a French girl who had been a governess in their family, and she had announced to her husband that she could not go on living in the same house with him. The position of affairs had now lasted 3 days, and not only the husband and wife themselves, but all the members of their family and household were painfully conscious of it. Every person in the house felt that there was no sense in their living together, and that the stray people brought together by chance in any hotel had more in common with one another than they, the members of the family and household of the Oblonskys. The wife did not leave her own room. The husband had not been at home for 3 days. The children ran wild all over the house. The English governess quarreled with the housekeeper and wrote to a friend asking her to look for a new situation for her. The man cook had walked off the day before, just at dinner time. The kitchen maid and the coachman had given warning. Don't know if you know this work, but again, the famous line at the beginning, it's probably not one of the 4 or 5 most famous opening lines in literature, but if you extended the list down to about 20, it might well make the first 15 or 20, and it's from Anna Karenina by Leo Tolstoy. And this is an interesting assertion that he makes. Happy families are all alike, but every unhappy family is unhappy in its own way. And if we were together as a group, we would discuss this a little bit, especially whether we think that Tolstoy is correct or incorrect in this. Since it's only me and there's no one to discuss with, I'll just have to tell you that my own opinion is that as great as this book is, Tolstoy is really off base here, probably. In fact, he may be exactly wrong, have the shoe exactly on the other foot. When we've discussed this before, different students have taken different approaches, of course, so you're welcome to your own opinion, obviously. But here's kind of what I mean. When you hear of marriages breaking down, or of households being unhappy, or a childhood being unhappy, it seems to me, at least, like a lot of the same issues, the same kinds of problems or ruts come up over and over again. Alcoholism, disagreement over finances, infidelity, lack of communication, whether to have children, willingness to sacrifice, maybe psychological factors. It seems like a lot of these things you really uh, you hear of a breakdown and it's very sad because it's a friend of yours or a family member, but when you get to the causes, it seems like it's fallen into some rut that you have heard other people fall into before. On the other hand, though, it seems, again, this is just my opinion, but that it's happiness that has more of a variety. Tolstoy is saying that unhappiness has more of the variety, but what I'm suggesting to you is that some people find very surprising ways to be happy, and where you see the kind of the surprise and the variety is more in happiness than in unhappiness. I'll just give you a couple of examples that I've encountered in my own life. When I lived in Texas, a friend of mine told me about a couple he knew, and they literally spoke different languages and did not speak the other person's language. The husband was an English speaker and the wife was a Spanish speaker, and neither one spoke the language of the other. Now, obviously, they could communicate, they did gestures, they knew a couple of words, but neither one really learned the other's language in any systematic way, and yet, from all appearances, a very happy family. You sometimes see wide age disparities. You may have seen Alice von Hildebrand just died a couple of days ago. She lived to a very ripe old age, and her husband had been the famous theologian Dietrich von Hildebrand. There's quite a gap in their ages, I think 30 years or more, and not the normal thing, not the usual thing. Maybe it's normal, maybe it's not, but it's not the usual thing. And yet, sometimes you hear of these couples who are very happy despite this big disparity. Father staying home with the children rather than the mother doing that. You hear of that. Again, not the most common thing, but it's something that does happen. Couples who are together all the time. I think most people advise against that and say some time apart is better, but couples who work together often find they're together all day at work and then all evening at home. They're literally together almost all the time. Again, does not sound like the best arrangement, but some people make it work. So anyway, I'm just suggesting that great as he is, Tolstoy may have the shoe on the other foot, and where we really see the patterns, almost, I hate to say it, even the ruts sometimes, is going to be in the unhappy situations that lead to breakdown. And I think that this is going to, that's obviously bad news that people keep falling into these ruts. I guess maybe the good news or the silver lining is that maybe it's something that we can study and be attentive for and to look out for, to see if there's something you can do in your pastoral ministry to help the person, but also if you're helping someone specifically who is looking for a nullity declaration, being attentive to some of these patterns to see, is this something that might indicate that the marriage was null and maybe the person can't obtain that declaration. So that's why we're kind of discussing patterns, or the absence of patterns. I think in some ways we could say that looking for these patterns or asking whether there are patterns is going to be a fairly prominent part of our class. Remember from our Canon Law 2 class that there are three great pillars that support marriage validity, or three things that marriage validity depends on. So for you architecture students, our pediment, the pediment of our temple here, has marriage validity carved on it. And the pillars holding up our temple are three. There are three in this example. Obviously, I don't think you could really have a building with only three pillars, but we'll do what we can. And our three pillars are canonical form. I'll turn them this way for you. Canonical form, impediments, and consent or defects of consent. These are the three things that marriage validity or invalidity depends on. We were just talking about patterns, especially these very unhappy patterns like alcoholism, infidelity. Probably these things are going to be especially important on our third pillar here, consent or defects of consent. Some of these things that may have become so bad that they may even prevent someone from legitimately exchanging consent. So that's one big reason we're going to be looking out for patterns as we go on. Okay, both we're going to be looking for patterns that exist, that are out there, but also for ways to identify them. We've probably all heard of these issues, these problematic issues, but they might be somewhat hard for us to identify, especially when we're having conversations with people who are discussing these very sensitive matters with us, and we might be little more than strangers to them, and this poor person across the desk from you is in the position of having to discuss the sensitive thing with she's lucky that it's you, hopefully a compassionate person, but unlucky in the sense of having to discuss it with someone who's nearly a stranger in some ways. Let's see. Keep in mind, even though we're as we go forward, we're going to want to do our best to keep our types of cases somewhat separate. So if we're talking about an impediment case, keep in mind that it's an impediment and not a defect of consent. However, recall that some factual situations can give rise to different grounds of nullity. For example, premarital pregnancy. That could give rise to a defect of consent that the person may have lacked the sufficient discretion of judgment because of the pressure of this pregnancy. But also, if because of the pregnancy, a family member or the other spouse tried to force you into, or force the woman into marriage, that would be an impediment, the impediment of force or fear. So even though we're talking about the same factual situation, the premarital pregnancy, we might have the impediment of force or fear if someone is forcing marriage on the person. Or I guess it could be forcing marriage on either person, maybe the pregnant woman forcing marriage on the father, or a defect of consent that this very serious situation is making it so that the person is unable to consent, and we'll talk more about that. There's some others too. For instance, we talked in canon law 2 about abduction or kidnapping, when someone's kidnapped. Or actually, in the West, when a woman is kidnapped. This only applies to a woman, whereas in the East, it also applies if the man is kidnapped. If there's there's a crime called abduction, and that's an impediment. So if someone's kidnapped and forced to marry, that could either be the impediment of crime, which includes kidnapping, or it could also be a defect of consent, that there's that force or fear has been brought to bear. Okay. So one of our tables, or one of our charts that we're going to keep in mind, is our temple with the 3 pillars. The other one is a pyramid that I want to show you, and if you had the Indianapolis personnel for your J-term explanation, then you may have seen this pyramid. If I think most recently Father Patrick gave the presentation. I don't know if he uses the same image, so I'll put it up in case you haven't seen it before. And this is something that the Indianapolis people, Ann Tully and Father Joe Newton, have used. And this is a pyramid that shows the different types of marriage cases. And you start at the top because the top is the easiest case, canonical form. That's why we're starting our class with canonical form. It's the easiest type of case. If someone can only marry validly, and if they follow canonical form, but they did not follow canonical form, it's pretty easy to see that they're still free to marry, that it's relatively easy and quick to resolve that case. So that's why canonical form is at the very top, because it's the easiest case to resolve. What's the second easiest? We're going to say impediments. It might depend on the type of impediment, but we're especially concerned with by far the most common impediment, which is prior bond, or you'll remember the Latin term legamen, meaning that we're married or we're civilly married, but one of us was married before and the previous spouse didn't die. There's been no declaration of nullity, so one of the spouses was not free to marry. If these two people now in the civil marriage want a declaration that they're free to marry other people, the one who's never been married before, or who's only had the civil marriage, it's quite easy for them because the one that they married already had married someone else, and that was a valid union, never declared null, not dissolved because of death or anything else. So there really was no marriage, even though the state would recognize it. The church would see the truth that there is no marriage. So we're going to say that's going to be the second easiest case, the impediment, specifically the impediment of prior bond or legamen. In the middle, we have the Pauline privilege. Now that's going to be a case where it starts out with two unbaptized people. One later becomes baptized, but the unbaptized spouse will not let the baptized spouse practice the faith. So that's where the biblical Pauline privilege comes from. That's going to be in the middle of our pyramid. Then the so-called favor fide case is going to be somewhat like the Pauline privilege, except one of the spouses might be baptized. The Pope can dissolve certain types of marriages. If it's a marriage that's not sacramental, it's not between two Christians, he could conceivably dissolve that marriage. Or even if it is between two Christians, but it's not consummated, then he could dissolve that marriage. So favor fide is going to be our fourth easiest or our second most difficult case. With favor fide, you're asking the Pope to dissolve the marriage. You don't have a right to the dissolution. You're asking as a favor or as a grace. So now we're getting to the most difficult. The most difficult case is what's going to be called the formal case or the formal nullity case. That's going to be essentially the full-blown marriage trial, the full-blown marriage case. And the reason we list them this way as a pyramid with the formal case at the bottom is the formal case is what we would like to avoid if we can. A lot of times you can't avoid it. That's the only way to get out of it is actually to examine it. That's really the main thing tribunals do. But you want to go through the first four levels first to at least ask the question, could it be one of these other types of case? Because if it is, it will be easier to resolve. Okay. And in our syllabus, if you look at the syllabus, you'll see we're kind of going to be following the pyramid as we go on. We're, again, going to be starting with canonical form and then going through impediments and then the privilege and then getting to the formal case. So we're, to some degree, going to be following the pyramid as we go along. Okay, that's essentially our just kind of our more general introduction. let's talk about some more specific matters. We're concerned with judicial power in the church, right? We talked in Canon Law 1 about how, just as in the civil government, we have legislative, executive, and judicial authority. We have those types of authority in the church too. So we're concerned primarily with the judicial power in the church. As we also said back in Canon Law 1, although we distinguish these powers, we don't have the same kind of separation of powers as we do in the civil government. So the bishop is not only the executive authority, he's also the legislator for his diocese, and he's a judge as well. So the bishop actually holds all three kinds of power. Might sound foreign to us who are used to the Anglo-American system, but we do have this in the church. And if you want to see this described, one of the documents for our reading today it's a document called Dignitatis Connubii, and this is in Article 22, where it talks about the bishop as judge. You can also see it in Canon 1419. Let me tell you a little bit about Dignitatis Connubii. For a number of decades, especially in the 80s, 90s, early 2000s, there was some concern that marriage tribunals were too lax. And as a result, a kind of a study was made, and in the early 2000s, a new kind of this document, Dignitatis Connubii, was issued, and it sort of tightened up the marriage procedure and required tribunals to follow a somewhat more regular procedure than allegedly some of them had been following in the past. So, and I think it's also answering some questions that perhaps were left unanswered in the original code. Let me see if I've got my Dignitatis Connubii. When it came out in this really nice, handy little red book. Unfortunately, I don't think this is available, or not very easily available anymore, but it's a shame because this is just a really nice sized book. What is available, though, and it's on our list, I think, of recommended readings, is a commentary it's much larger, and it's a green volume by two canonists named Ronnie Jenkins and someone Luedecke. I think he's a German. I forget his first name. I think it might be Karl or something, but I think it's Luedecke. So Jenkins and Luedecke. And it's on our syllabus. And that has the text of Dignitatis Connubii, but it also has a commentary on it, which is very good. So this is a useful document. However, after this document came out, let me see if I can find the year, 2005 is when this came out. So right at the end of John Paul's pontificate or beginning of Benedict's, right around there. However, 10 years later, Pope Francis made some significant changes to marriage law. So, unfortunately, some of the canons that Dignitatis Connubii is based on have been changed. So you do have to take care that when you're using Dignitatis Connubii, you're using it for canons that either still exist or canons that a revised version that's substantially the same still exists. The canon number could be somewhat different, or the canon could possibly be gone. So there's another step you have to do. To some degree, there's been, I think, maybe some movement away from using Dignitatis Connubii in recent years because of this circumstance, but it's still a good document. It just is a little bit trickier to use because you do have to verify what the current law is. Okay, so the bishop as judge, you can find that in, I'll just say DC for now, DC Article 22. However, although the bishop is considered a judge, he does not usually exercise judicial power himself. This is changing somewhat because Francis actually wants bishops to exercise it more often, but traditionally they have not exercised it all that much. And as a result, a bishop always or almost always appoints a judicial vicar who becomes really the chief day-to-day judicial officer in the diocese. Um, okay, when a when a when there's a nullity case, a case for the nullity of marriage, which is for all intents and purposes almost the only type of case that church tribunals uh, rule on. Um, when there is a nullity case, the basic rule is that it should be judged by what's called a collegial tribunal, collegial like college tribunal of 3 judges. Um, However, it's possible for, if there's a shortage or there's a need, there's it's possible for just one judge to be used, and you can find this in DC 30. Now, with Pope Francis's changes to marriage law in 2015, uh, it it looks like this is going to become even more common, it's going to become even more prevalent to have cases judged by just one judge instead of a college of 3. Okay, um, let's talk for a little bit about the different types of tribunals in the church. And these are ones that you may encounter yourself or that you may just have heard of. So we'll talk about tribunals in the church. The first type, of course, is your diocesan tribunal, the tribunal of your own diocese. Now, I've got the word interdiocesan underneath there. Some dioceses do not yet have a tribunal established, and so they may have their cases addressed by a different tribunal, or they may share personnel and have a tribunal that covers more than one diocese. Then there's also a metropolitan tribunal. So now, in a province like Indiana, a diocese like Evansville, uh, what they're going to do is if someone appeals, usually that appeal is going to go to the Metropolitan Tribunal, which would be the Metropolitan See, or Indianapolis. Indianapolis in Indiana, Chicago in Illinois. It's usually not too hard to figure out. There usually in each province, there's several bishops, diocesan bishops, and then one diocesan archbishop, and the see that has the archbishop is the Metropolitan See. Now, the Metropolitan See will also have a tribunal um, to hear regular cases, initial cases, but they'll also have this appellate tribunal, this Metropolitan Tribunal. Some countries have what are called regional tribunals. It's not too common throughout the world, but some countries have them. And the one I know of is Italy. I think Spain may have them too. And I don't really know of too many other places that do. And like I say, I'm not even 100% sure about Spain. And then you may remember this from Canon Law 1. There are several tribunals of the Holy See. The Roman Rota is the first one that we care about because it's probably the most important for marriage law. And the Rota is basically the ordinary appellate tribunal for marriage law. Now, we said that here in the U.S., what we might do, not just in the U.S., but other places too, the appeal might well go to the Metropolitan Tribunal, but it also could go to the Rota. Sometimes people want their appeal to go to the Rota. So the Rota has a lot of marriage appeals. And then there's another tribunal above the Rota. The highest tribunal is called the Apostolic Signatura. And so usually there's not an appeal after the Rota, but if there is, it would go to the Signatura most of the time. And then 2 tribunals that don't concern this class, the Apostolic Penitentiary. The Apostolic Penitentiary is concerned with the internal forum. And then the CDF, the Congregation for the Doctrine of the Faith, we think of it as a primarily a teaching office, but they also rule on cases involving serious crimes, or what are called graviora delicta, grave delicts in the church. Okay. Excuse me. Okay, so those are our tribunals. Now we've got some language that we need to talk about. You're going to hear this term called an instance. What is an instance? And you're especially going to hear first instance or second instance is where it usually will come up. What this basically refers to is the grade of the tribunal. That last word is hard to read, but it says grade. And this is easiest to understand if we have an example. I'm going to give you an example from before 2015, before Pope Francis reformed the marriage law. You may have heard that there used to be an automatic appeal in marriage law. You didn't just get a case heard in Evansville, and then if it found for nullity, you could marry again. You had to have a higher court affirm that decision before you could act on it, and that second judgment was called a conforming sentence or a conforming opinion. Sometimes it was called an automatic appeal, but something like obligatory review would probably be a better term. So in the old regime where you had this automatic review or obligatory review, it was easier to understand, and you heard it more often, this talk of first instance or second instance. So let's say we've got a case in Evansville. You've got a parishioner who wants to have their marriage declared null. Evansville receives the petition. That's the first instance tribunal. Now again, we're talking pre-2015, so let's say Evansville finds for nullity. And then you have to have, if it's before 2015, you have to have this second conforming sentence that agrees with it before you could actually go and act on the sentence. Well, then you'd have your mandatory review or automatic appeal, and it would go to Indianapolis, the Metropolitan See, and that would be the second instance tribunal. It's just really the second court who's heard it. And it's usually going to be a higher court because you appeal to a higher court, of course. Let's say Indianapolis disagrees. They say, no, we think the marriage is valid. Well, then, if somebody wants to, they could appeal to the Roman Rota. So the case would be at the Roman Rota in third instance. Let's say the Roman Rota says, we agree with Evansville, the marriage is null, but we think it's null for a different reason, not because the husband lacked due discretion, but because the wife lacked due discretion. That's a different ground. And you only say that sentences agree if they agree on both the decision and the reason for it. So even though the Rota agrees with Evansville's result, they disagree with the ground of nullity. So that's not a conforming sentence. So if someone still wants to act and get married, they're going to have to go to fourth instance, which would be, in this case, the signatura. Very rare that a case ever gets to fourth instance. Most cases only would go as high as second instance, but it is theoretically possible you could have a case going as high as fourth instance. So it's fairly easy to understand what the word instance means, but just keep in mind that a court could be first instance in one case, but second instance in another. For example, there's a few cases where, for instance, cases involving dioceses, so not a marriage case, but a case involving a diocese, where the Roman Rota is the court that hears them initially. Well, then in that kind of case, because the Rota is the first court that hears it, in that type of case, it's first instance. Or let's say this: I didn't like the decision of Evansville, and I didn't want to go to Indianapolis. For some reason, I didn't want to appeal to their tribunal. I wanted to appeal to the rota. You could do that. You didn't have to go to the Metropolitan Tribunal. Usually they would go to the Metropolitan Tribunal, but you didn't have to do that. So if I just went right to the rota and skipped Indianapolis, then the rota would be hearing the case in second instance, not third instance, because there'd only been one previous court. So a different court can be acting in different instances. So the instance refers not only to the grade of the court, but also to the stage in the procedures in this particular case, who's been the first one to hear this case, etc. Okay. All right, so now our kind of the next thing we would like to talk about is personnel in the diocese. And some of these you will have heard of already. We've already talked about. So we said the bishop, in a sense, is the chief judge, but for the most part, exercises that power more through the judicial vicar than personally. So here are some of our officers. The judicial vicar are an important one. Sometimes you see him called the officialis. Officialis. I don't know where he's called the officialis, but it seems like the overwhelming number of places in the United States he's called the judicial vicar. I think sometimes you see Woodall say the vicar judicial. That's fine, it's obviously the same person. But he's the judicial vicar is the head of the tribunal, and he's a judge too. He has the power to judge. And then next we have the AJV, which is the assistant or the adjunct judicial vicar, but there can be more than one. You can have more than one assistants. You might need a number of them, depending on the size of the diocese and how busy they are. And then you have judges. Now, for the judges, both clergy and laity can serve as judges, and you see this discussed in Dignitatis Connubii 43. By the way, I forgot to say it, but the office of judicial vicar is discussed in Dignitatis Connubii 38, as well as Canon 1420. Judges are discussed in Canon 1421 and in DC 43. Now, on a panel, let's say you're having a collegial tribunal, let's say there are three. On a panel, usually the judicial vicar or assistant judicial vicar would be what is called the praeses, Praeses, or the presiding judge. He's going to be the presiding judge, so it usually would be a cleric. However, the cleric who actually writes the sentence, really writes the decision for the court is called the ponens. The ponens, Ponens, and that could be a lay person. Okay, our next person is an auditor. The auditor is somebody who helps collect the proofs. So they might help interview witnesses, they might take testimony, and again, it can be a lay person or a member of the clergy. And this you see in DC 50 and in Canon 1428. With this word auditor, keep in mind there is a separate, so an auditor, because they're helping in the tribunal by collecting evidence, it's kind of a mid-level person. They don't have nearly the authority that a judge or a judicial vicar or AJV has. However, you'll sometimes hear the phrase auditor of the Roman rota. In fact, the Pope, early in the year, usually January or February every year, gives an address to the Roman rota, and it's always called the address to the auditors of the Roman rota. In that sense, and that's auditor with a capital A, auditors of the Roman rota, those are judges. It's just a very old usage. I'm not sure why they call them that, but when you hear auditor in a diocese, it's somebody who's kind of helping with the case, almost kind of a clerical person, but a much different thing if they're an auditor of the rota. So you meet somebody at a cocktail party and they say they're an auditor. Don't just turn out, oh, this person isn't all that interesting. If they're an auditor of the rota, you're going to be the one getting them the martini. They're not going to get you the martini. Okay. Auditors. Assessor. The assessor is someone, if there's a case that has only one judge, just a single judge, then the assessor is someone who helps on a case that has only a sole judge. Sort of help evaluate the evidence, etc. And the assessor can be either a cleric or a lay person. And you see this office discussed in Canon 1424. Next, very important, I've just got DB here. That's the defender of the bond. Very important. This is somebody who, he doesn't represent the person asking for nullity. He doesn't represent the other spouse either, but his client is the marriage bond. Our problem in a marriage case is that it might be that both spouses want the same thing. A trial is really designed, in a sense, for the truth to come out by having people who disagree present contrary evidence and see whose is stronger. The problem in a nullity case is they might hate each other so much they both want to have the marriage declared null, or there might be someone who just doesn't care what happens, so they might be an absent person. So to ensure that there's kind of rigor in the process, we have this office of the defender of the bond here at the bottom, and his client or her client is the bond, so he or she has to defend the bond, and can't act in favor of nullity, but only in favor of the bond. And this also can be a cleric or a lay person. Okay, our next person is the promoter of justice. If you just read the canons, you'd probably think the promoter of justice was more important than they were. The promoter of justice can intervene and take part in a marriage case. In fact, I think it's extremely rare. So I think that's more of a hypothetical possibility than a real one. The next one I have that says judge instructor. Now that's an office they had in Indianapolis, and one of these folks who used to come for J-term before she retired was named Ann Tully, and she would give some of our presentations. And so she was a very well-informed, very skilled layperson. She wasn't a canonist, but she had great knowledge and ability in marriage law, both because of her own abilities, but also because of her experience and the long time she worked on the tribunal. And so she worked in this position of a judge instructor. So she described it as being like a law clerk. She would actually help draft the sentences. She would actually help the judges in their drafting of the sentences. There are probably, I don't know if they're always called judge instructors. That's what they were called in Indianapolis. Probably, even if they're not called this in your diocese, there may be somebody like this. Then the next person is a notary. I should say ecclesiastical notary, because you'll have documents that need to be notarized, so you can have them notarized. The chancellor actually is always a notary too. So if you don't have someone who's just a notary, you could go to the chancellor. And then finally, the advocate. There, either or both parties may have an advocate, and so we have the advocate who's listed there. Okay, that's our personnel. We've talked about types of tribunals. We've talked about the judicial power. We've talked about tribunal personnel now. Okay, what else should we talk about? Remember we said when we had our pyramid up, our real goal, in fact, the whole real goal of drawing a pyramid like this is to highlight that what we really want to avoid, if we can, is the formal case. A lot of times you can't, because that's the only way you're going to have to take the evidence. The others just don't apply. The things you need for one of these other cases don't apply, but you want to go through the analysis, because boy, it's so much easier of a case if it's a canonical form case than a formal case. It's the difference between a couple days or a couple weeks versus a case that could take months or potentially close to a year. So what we want to do now is take a look at the formal case and see what's involved in it. It's going to kind of help us to see why we want to avoid it, mostly just because it's going to have a number of steps and then sub-steps, but it will kind of familiarize you with the procedure so that you'll be able to explain it to your parishioners when they ask you. This description is from Indianapolis, so it could be a little bit different in other places. But if you need another one or want to see one that's similar but maybe with a little bit of difference, Woodall also has a description of the nullity process. I forget exactly where it is. I think it's in the 400s, but you'll be able to find a nice description there too. But I'll give you what we would have in Indianapolis first. So we're talking about a formal nullity case. This is the bottom of our pyramid, our most difficult case, and what our stages are. We're going to have essentially 4 stages. The first is the introductory stage. Well, what happens there? The petitioner works with somebody who in Indianapolis they call a field associate. Different places call them different things, but a lot of dioceses have somebody like this. And it's someone who's been qualified usually to help people with their petitions. So somebody may have gotten a certificate in a certificate program, something like that. And what they're doing is they're meeting with the potential petitioner and getting the basic data to try to figure out what kind of case this is going to be. We'll figure out, is it going to have to be a formal case, or does it turn out that there's previous marriages, or there's someone who should have gotten married according to canonical form but didn't, so that we have that type of case. So this initial intake is going to help us figure out what type of case that we're talking about, and the field associate is going to help. Now, often in Indianapolis, the pastor is going to be the field associate, or it may be another priest, or it may be all priests in parish ministry, but it could be other people too. It could definitely be lay persons or religious, etc. It's the pastor's probably going to have to do at least some of these cases, so it would be good if he were qualified as a field associate, and I think as a rule they usually are in Indianapolis. The field associate also can help with the gathering of evidence, at least at the beginning. What types of evidence? There's a question. The big thing is that there's a questionnaire. If it's going to be a formal case, there's a questionnaire that's going to have to be filled out, and it's somewhat lengthy. It's different in every diocese, but all of them take some work. And some people just you take writing for granted because you do so much of it. Some people don't, and really have a great difficulty with a form with that many pages, and they really need your help. So they may be telling you their story, and you are actually going to be the one to really fill in at least parts of the questionnaire. What other types of documents? Baptismal certificates. We're going to need baptismal certificates in a formal case. What else? A divorce decree. All tribunals in the U.S. require, before they'll proceed with a formal case, they require that the couple be divorced, so that that a civil divorce decree has been issued. If there's let's leave it there for now. Okay, what happens then? You've got the petition together, or not the petition, you've got the questionnaire, the documents, the baptismal certificates, the divorce decree. You send it to the diocese, and it's reviewed by the tribunal, and they either accept it or they reject it. Now, if they reject it, hopefully they'll tell you why. And if they accept it, what they do is they will prepare a libellus. A libellus is what in the civil realm, you would call a complaint. It would be the document that actually initiates the the litigation. So the tribunal prepares a libellus, a short document about 2 pages. The tribunal prepares it, and then the respondent is cited. Now, in marriage law, we're not talking about plaintiffs and defendants, but petitioners and respondent. The petitioner is the person who's seeking the nullity decree, and the respondent is the other person. The respondent may agree or may decide to defend the marriage, or very often just chooses not to participate in the case at all. And but the respondent, once the libellus is prepared, the respondent needs to be cited. They need to be informed that there's going to be this case going on. And what happens is what's determined is the point at issue, which is called the litis contestatio. This is going to be what the case is about, or the framing of the question, what the case is about, whether this wife or whether this husband lacked due discretion for such and such a reason. So the litis contestatio is going to specify what the point at issue is. Okay, that's the introductory stage. Where do we go from there? We go to, we've been to the introductory stage. Now we go to the evidence gathering stage. What happens there? Well, we need to interview the respondent, if the respondent will speak with you, and other witnesses. When you fill out your questionnaire, you need to list other people who may be able to serve as witnesses, especially people who knew the couple around the time of their courtship and their marriage, or early in their marriage. And experts also may need to be contacted and may need to weigh in. For example, if there's a psychological cause, we're going to very likely need an expert to say, yes, there's a real psychological problem or disorder here. And in fact, later in our semester, what we're hoping is that to actually get one of these psychological experts who works on marriage cases, and to have her, if she's available, come and speak to our class sometime in the spring. So keep your fingers crossed that that works out. Then what happens? Then the evidence is evaluated by the advocates, and it can be inspected by the parties, and then comes, this is called publication, and the defender of the bond also must be permitted to see the evidence as well. Then the case is concluded. The judicial vicar declares that the evidence is complete, and the parties, including the defender of the bond, submit their arguments. That's the end of the evidence gathering stage. So what comes next? Okay, we've had the introductory stage, the evidence gathering stage, then the decision stage. And this is just where the judge decides, or the panel of judges decide, and then the ponens writes the decision, writes the sentence, and the decision then is communicated to the parties, and they're informed of what the tribunal decided. And what's our last stage? Appeals. If either side wants to appeal, or the defender wants to appeal, they can now appeal. Okay, just one more thing that we'll do today, and then we'll call it a day. We're going to distinguish between two different types of events. One is called a judicial process, and one is called an administrative procedure. So I'm going to try to reserve the word process for something that's a judicial process. It takes place in the tribunal, judges are involved, etc. Whereas I'll try to use procedure for the administrative type of action that does not necessarily involve a judge and is not necessarily an action of the tribunal. When we talk about a judicial process, what we really have in mind is the full formal nullity case, the actual trial. Or if we were in the penal sphere, a penal trial, something that actually has this full thing that we've just talked about, all these different stages. That's why we say the judicial the whole full judicial process is more protective of rights than an administrative procedure, because it's got more stages and more opportunity for the defendant or respondent or defender to intervene. Um, so that's the judicial process. But there's also, and when we think of marriage, we usually think of judicial processes and nullity trials, but we also have to think about administrative procedures because we have some of those. One of those is for convalidation. You're going to have somebody, if they had some difficulty, for instance, some impediment. They married, but they had an impediment, so their marriage is invalid, but the impediment has ceased. Let's say the impediment was legamen. I married this woman, but I already had been married. However, the person who I used to be married to has died now. So now I am free to marry. Now I could have this marriage, I could have this marriage regularized. So we would do that in a convalidation. And sorry about that. The convalidation would not be a judicial process, it would be much simpler. It would be an administrative procedure. Okay, I'm out of voice. What else? Separation of the spouses. We won't talk much about that. That's also an administrative procedure. In favor of the faith. Apologize. Or favor fide. That's not a trial. It's not something you have a right to. It's something that you ask the Pope for as a favor or as a grace. So it's an administrative matter, although the tribunal personnel also will work on it. Apologize for my coughing, and I'm sorry again, our classes looks like it's going to be canceled, but I'll see you, if not tomorrow, then on February 10th. Thank you.